The Supreme Court just upheld a law that bans certain people from owning and possessing firearms. Yes, you heard that correctly. The Supreme Court says shall not be infringed actually can be infringed in certain circumstances, as it has been in this country since its founding. And this decision wasn't even close. The ruling was 8-1 with the majority opinion written by Chief Justice John Roberts. There were several concurring opinions and Justice Clarence Thomas dissented. And I will explain his position in a second, but first you need to understand this case. In United States versus Rahimi, Rahimi is Zaki Rahimi, a convicted drug dealer from Texas who had a court-ordered restraining order against him for allegedly assaulting his girlfriend. Both federal and Texas state law bans people with domestic violence restraining orders from possessing guns. Well, after that restraining order was imposed, Rahimi was involved in multiple shootings in Texas. He was indicted by a federal grand jury for possession of firearm while under a domestic violence restraining order. But he sued, saying that federal law that restricts him from having guns violates his Second Amendment right. And the Fifth Circuit Court of Appeals agreed with him. The Fifth Circuit said because of a landmark Supreme Court ruling in 2022 that established the Bruen Test, the federal law and Texas state law banning people with domestic violence restraining orders from possessing guns is unconstitutional because it's not consistent with the nation's historical tradition of firearm regulation. But today, the Chief Justice said the Fifth Circuit, like many other lower courts, got it wrong. They misapplied the Bruen Test in Rahimi's case. The Chief Justice clarified how to apply the Bruen Test to existing and future gun regulations. He said in order to legally restrict someone's right to possess firearms, the law to regulate it must comport with the principles underlying the Second Amendment, but it need not be a dead ringer or a historical twin. The chief says since there was a court finding that Rahimi had a long history of repeated violence, not only against women, but other people and several other crimes, it was lawful to restrict his gun possession. The chief said our tradition of firearm regulation allows the government to disarm individuals who present a credible threat to the physical safety of others. When an individual has been found by a court to pose a credible threat to the physical safety of another, that individual may be temporarily disarmed consistent with the Second Amendment. The chief said the Supreme Court had no difficulty in overturning the Fifth Circuit in Rahimi's case, saying it was common sense. The majority opinion says while the right to bear arms is a fundamental right in the United States, like other rights in this country, it is not unlimited. In his dissent, Justice Clarence Thomas said no. When a court is using the Bruen Test to decide legality of gun regulation, it needs to be a historical twin. Thomas, who actually wrote the Bruen majority opinion, said in this Rahimi case, the court and government do not point to a single historical law revoking a citizen's Second Amendment right based on possible interpersonal violence. The government has not borne its burden to prove that the law that lists who is prohibited from possessing firearms is consistent with the Second Amendment's text and historical understanding. So if you want to read this ruling and all the concurring opinions and the dissent, I will email it out to you tonight in my News Girl News Roundup email, so make sure you sign yourself up.